Right, let's get back to the story now. The High Court in Pretoria has reserved judgment in the high-profile legal battle concerning the method of publishing the annual National Senior Certificate Examination results by the Department of Basic Education. The court dispute is whether the DBE's practice of publicly releasing Matric results, even if only by examination number and not full names, violates the provisions of the South African Protection of Personal Information Act. Let's unpack this further. The spokesperson for the Information Regulator, Nomzamo Zondi. Nomzamo, good to have you. Thank you very much for your time. What are the key tenets of this debate, whether for or against the publishing of Matric results?
Good afternoon, Thabo, and good afternoon to your viewers. I think we have to just give a little bit of background in terms of this issue. Firstly, as the information regulator, we are empowered by the Protection of Personal Information Act to actually conduct compliance assessments with POPIA. And that's what we did back in 2023 with the Department of Basic Education, whereby we conducted an assessment to check their compliance with the law. And we did find that there were some inconsistencies with their compliance with POPIA. So as a result, last year in November, we did issue an enforcement notice to the department, whereby we were instructing the department to not issue or publish the Matric results of the matriculants that sat in the year 2023. So when we issued our enforcement notice, we were very clear that the department needs to obtain consent from learners that are 18 years and above, and from the parents of learners who are below the age of 18. Obviously, they need to get permission from a competent person, which is their parent or guardian. So in our enforcement notice, we also indicated to the department that you are not compliant with POPIA, and you need to also demonstrate to us that how is the processing of the learner's examination or results through their examination number necessary for either concluding or conducting a certain obligation that you have as a department. But what we also had indicated to the department through the enforcement notice is that they need to adhere to our instruction that they need to apply a randomized approach or in a non-sequential manner of the exams in the Matric when they are publishing the Matric results. So we had issued that enforcement notice, which is as good and binding as a court order, and the department failed to respond to the instructions that we had in that enforcement notice we issued last year.
Yeah. So your argument is not in the publication, but in the manner in which this is published. Is that correct?
I think it's very important for us to indicate, Thabo, that as the information regulator, we have no intention of barring the processing of personal information. But what we do, in fact, what we do encourage is that there has to be processing of personal information within the provisions of POPIA. So that is exactly what our enforcement notice was urging the department, for them to obtain the consent, for them to ensure that you cannot identify an exam number and link it back to a learner who's writing that exam or who owns that examination number. So that is what we are arguing here, that we need to ensure that there's consent that is obtained for the publishing of these results, but also the randomization of the examination number must not be in a manner that you are able to then link it back to a learner, whether you are in the same school or not. So the exam number itself is a unique identifier, and that is regarded as personal information. And to process that, you need to do it within the ambits of the law. And that is exactly the argument that we're putting forward.
Okay, so you're arguing that the examination number is personal information. The department saying, well, it's not, it cannot be linked and it can be construed as personal information. It's just a number to facilitate the publication of results.
We would say that is not entirely true, because following our assessment, we did notice that the examination numbers are in a sequence. And if, Thabo, you are assigned an exam number and we go to the same school and I go to the same school as you and we sit next to each other, even if you are exam number 1, 2, 3, 4 and I'm exam number 1, 2, 3, 5, I will be able to know when the exams are published whether you did pass or did not. And that in itself is attaching a unique identifier to you, and I will be able to make distinction whether you did pass or not, should the exam numbers be published in the newspaper. And also, like I indicated, in our enforcement notice, we did not say that they should not publish exam numbers. We said they need to do so in a way where they will randomize the numbers, or it is not placed in a sequential manner, and then learners within the same school or roads in the same exam center will be able to link that back to a certain or specific learner.
Well, AfriForum argues that, well, there are different dates for examinations, different subjects, so different seating arrangements as well. How would one be able to cram, for lack of a better word, somebody else's examination number that they wrote yesterday?
That has not been brought in to us, as I indicated that when we did issue the enforcement notice, that is one of the things that we wanted the department to clarify to us. But according to our assessment, that is what we have picked up, that those numbers are sequenced. And yes, you may argue that you may not be able to cram all learners' examination number, but that one or two learners that you are actually able to identify through their exam number is one too many of learners, and you have to ensure that there is no way that one can identify another learner using their examination number. So it is important, Thabo, for us to understand that when this was presented as a tradition and something that is done, we have to understand that there has been the introduction of the Protection of Personal Information Act in the country, and we have a responsibility to ensure the right to privacy of everyone and every learner, even if it is one learner, that we need to protect their privacy in such a practice. And like I keep emphasizing, that we did not bar the Department of Education to process personal information. We urge them to process information in a lawful manner and within the provisions of POPIA, following the condition for lawful processing of personal information.
At what point is it over-regulating? At what point does it become an infringement on what the others are arguing is the media, Department of Education, and interest of pupils, freedom of information, freedom of the press, and the importance of an open and transparent society?
I think we are obviously mindful of the tradition. We are also mindful of the right of access to information, transparency, media freedom, and so forth. However, I think the practice of publishing of matric results globally, I think we're one of the very few countries who even still follows that practice. But we need to be mindful that in the introduction of the law, we have to ensure that tradition and practice is also alive and aligned to the laws that are introduced as well. So we can indicate that our stance as the information regulator is that we have a responsibility to ensure that the right to privacy is protected. And after conducting an assessment and finding that there was inconsistencies in applying the law, we had to ensure that there are measures put in place, which we did instruct the department to follow. And again, Thabo, as I have been saying, we are not saying that there shouldn't be processing of personal information, but we're emphasizing that it needs to be done. It needs to be done within the provisions of the law.
Appreciate your time. That's Nomzamo speaking for the information regulator on that battle currently in the court. Of course, judgment currently reserved. Of course, courts still applying their mind on this particular matter.